Ready, start. In pursuance of the disclosure statements of the accused persons, seizure was effected by police, full stop. At the conclusion of the investigation, a charge sheet came to be filed in the Court of Judicial Magistrate First Class, Drug, full stop. Since the case was exclusively triable by the Sessions Court, the same came to be committed to the Sessions Judge, full stop. The accused persons were examined under Section 313 of the Code of Criminal Procedure, 1973, wherein they pleaded not guilty and claimed to be tried, full stop. The prosecution examined 18 witnesses to bring home the guilt of the accused, full stop. At the conclusion of trial, the trial judge found that the prosecution had succeeded in proving that the appellant had committed the murder of the deceased, full stop. The prosecution further proved that the accused persons committed criminal conspiracy to destroy the evidence, and threw the body of the deceased after burning the same behind the Baba Balaknath temple, full stop. The prosecution also proved that accused number 2 helped in throwing the body of the deceased and destroying evidence by way of cleaning the blood stains etc. of the deceased, full stop. Thus, the trial judge convicted the appellant for offences punishable under sections 302 and 201 read with 120b of the Indian Penal Code, 1860, and was awarded a maximum sentence of life imprisonment, whereas accused numbers 2 to 4 were convicted for offences punishable under sections 201 read with 120b of IPC and were sentenced to undergo rigorous imprisonment for 5 years and fine of rupees 1000, full stop. Being aggrieved thereby, the appellant and other accused persons preferred appeals before the High Court through CRA number 223 of 2012 and CRA number 38 of 2012 respectively, full stop. The High Court by the common impugned judgment, although allowed the appeal filed by the accused numbers 2 to 4, however, it dismissed the appeal filed by the present appellant and affirmed the order of conviction and sentence awarded to him by the trial judge, full stop. Sri Samir Srivastava submitted that both the trial judge as well as the High Court have grossly erred in convicting the appellant, full stop. It is submitted that there is no evidence at all which establishes the guilt of the appellant beyond reasonable doubt, full stop. It is submitted that the finding of guilt of the appellant as recorded by the trial judge is based on conjectures and surmises and, therefore, not sustainable in law, full stop. Learned counsel further submitted that, from the evidence of the father and brother of the deceased, it would reveal that the dead body of the deceased has not been identified and the prosecution has failed to prove that the dead body found in the garbage was that of Shiva, full stop. On the contrary, Sri Samir Sodhi submitted that both the trial judge and the High Court, upon correct appreciation of evidence, have found the accused as appellant guilty of the charges leveled against him, full stop. It is submitted that, as per the FSL report, human blood was present on the dagger which was recovered at the instance of the present appellant, full stop.